welcome to the Personal Injury Law Show. This show talks about anything current in the law of personal injuries and obviously of significance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me today I've got another very senior accredited specialist in workers' compensation, John Karantzis. Good evening, John.
Hi Tony, hi viewers.
And a senior lawyer in a law firm in workers' compensation, Toby Robinson. Good evening, Toby.
Hi Tony, hi viewers.
Tonight, viewers are going to give you an update on workers' compensation law because there's a lot of cases.
Before we get to that, Tony, what's in the news?
Well, John and Toby, there's been a lot of stories, but the one that really got my eye, John, was this Thermomix machine. Costs about $2,000. Seems like every household has got it.
Sorry, how much did it cost?
About $2,000 bucks, I think. I'm pretty sure.
And what does this machine do?
Well,
Thermomix.
Apart from blowing up.
It mulches food, and this is blown up on this poor lady in Perth.
So it did what it wasn't supposed to do, but apparently they've sold 80,000 appliances in the last X number of years. So it's a very popular machine. This is a very serious case where a lady's suffered horrific burns, and I'll tell you what, she's got a fantastic claim, I'd imagine. What do you think, Toby?
Oh, I agree, Tony. I mean, it's quite alarming, actually. My understanding is they're very popular, these machines. I know somebody
80,000 of them.
Yeah. So this poor lady, Danica Jones, was cooking a pasta sauce in her home in Perth, Tony, and it blew up all over her.
Yep.
And you could see the photos, the third-degree burns she suffered.
Oh, it's horrendous injury.
Horrendous.
Yeah.
So it's a
What's currently, she's had a lawyer at Sloan Gordon. Naki LaRue is investigating the claim.
It's a good claim.
Yeah, I think so. And apparently there's been more than one incident. So, product liability case and or just negligence.
Negligence,
Yeah. All right, we'll keep moving. There's been an absolute escalation in the number of ladder falls and injuries over the years. Toby, I find it astounding how many people go up on these ladders and keep coming off.
That's right. Well, the article in the news suggests that people, just getting up on the ladders too often and perhaps at too elderly an age.
Tony, on average, 3 people die a year from falling off ladders. At home, pruning the garden, pruning the trees, and if you're over 55, the risk is very high. Well, and literally, you should not be getting up on ladders if you're over 55 years of age.
I'm also a firm believer that if you get up on a ladder, there should be someone down the bottom of the ladder holding it for you, or at least giving you some sort of direction, because more often than not, when you're on the ladder...
And to break your fall.
That's right. But when you're on the ladder, you're usually up there for a reason. You might be cutting a tree or, cleaning a gutter.
Don't get on.
Yeah.
Don't get on.
Now, look, I've been on the ladder a few times, but I usually like a spotter down the bottom, so like you said, it breaks your fall.
You're
That's
asking
actually
for
not
trouble.
funny. It's serious business there.
It's serious. A head injury from a fall of only 3 metres high can be fatal.
Well, we've got a case we're going to do in the next segment of a young fella that fell off a roof because there was no guards.
Yeah.
So that'll be an interesting story. The slip that cost Coles $300,000. Toby, tell us a bit more about this.
Yeah, this was a case about a lady who slipped in Coles. She slipped on, I believe, some tiles, and it was a bad slip, and she injured her ankle, and she ended up having a significant claim against Coles, which was successful.
Now, this is in Sydney, in the western suburbs of Sydney, Tony. She's walking along in a Coles store in the fruit and vegetable department, slips on a slippery substance of some sort. Very serious injuries.
Oh, yeah. She did the splits and she severely injured her left ankle. Just shows you, I mean, when you're dealing with these sorts of scenarios, supermarkets in particular, you almost need someone around the clock to watch what's on the floor because sadly, when people are shopping, they're always dropping lettuce leaves, grapes, all sorts of things. So it's an absolute hazard, isn't it?
And $300,000, Tony, it's a significant sum.
Oh, especially in New South Wales where you've got all those funny tests in terms of being able to claim.
Yeah.
Anyway.
So she's done
not
well.
up her alley, that one. Hey, what about this? In the modern workplace, the age of 50 is considered old. I find this very, very offensive. I reckon I found my niche at the age of 50. What do you reckon, huh, John?
Tony, it's a concern.
Yeah, look, I mean, they got a picture of Robert De Niro in that movie recently.
Yes.
Where
he acts as an intern. And he's
was
over 50. I think he's probably 65, actually, but anyway.
Yeah, he was actually 70, if I'm not mistaken.
Oh, right.
But,
exactly.
What's a significant issue with the retirement age potentially going up?
Well, the Commonwealth Government wants us to work post 70 years of age, yet, however, you're deemed too old if you're over 50 years of age.
Yeah,
so,
employers aren't sort of following through with that.
John, our
logic.
friend Dr. Pathak's 93 and he kept working and he said because it stimulates his brain and keeps his body going.
Exactly.
I mean, there's a lot to be said about that. I mean, people, you just don't work for the sake of making money.
No.
You've got to fill your time somehow, don't you?
Yeah, it has a personal sort of achievement side to it.
I reckon we've got to commend people like Dr. Pathak. I mean, there should be more of him out there, and that way, instead of paying $160 billion a year to sell a league, it'd be a lot less and we wouldn't have a black hole in our budget.
No.
Anyway, John, you keep banging on these guys. Hal Hunter tried to sue the Essendon Footy Club. He went to court to get discovery of documents. Apparently he did not win because everything he was after had already been handed over to him.
Yes.
Now he has to pay costs. I mean, it's
a bit rich on the Essendon Football Club asking for costs in a situation where they've caused the problem in the first place, isn't it, Tony?
But we don't know what the problem is. He's talking about how it's affected his well-being and welfare.
Well,
we don't really know.
I guess that's why he was seeking discovery.
His concern is he does not know what he's been injected with. He wants full discovery and not the apparent measly sum of documents that were given to him.
Yeah, I don't know. What do you think about this?
Well, it's an interesting case. You can understand why he'd be seeking some evidence just to clarify what he's been given. But I suppose on the other hand, Essendon says, well, we've given you everything, which is not much. But
which is not much.
Yeah.
No, well, I mean, they didn't have any documents. That was half the problem. I mean, everything sort of went into the incinerator or that self-destruction kit, you know.
The old I know nothing defence.
No, 007, self-destruct. But anyway, look, that has been a very tragic set of circumstances with the Essendon Footy Club, hasn't it?
It has.
Well,
and,
I'm waiting for the class action, Tony.
What, do you want to represent it?
Oh, well.
Not a bad case.
We're happy to help.
Yeah. New South Wales, another massive accident on the road. There seems to be one every day in New South Wales. Truckie was guilty of negligence where he slammed into a car, killed everyone.
Killed two people.
In the car.
Shane Anthony Day, Tony, he was cleared by jury just recently of dangerous driving occasioning death. However, a judge has found him guilty of negligent driving.
So what's he going to get for this, or what does he get for it?
Hopefully some jail time. However, we don't know, Tony.
Toby?
Well, you know, it's a very concerning case. He was, I think the suggestion in the article is he was going above the speed limit.
Oh, yes, that's clear.
Going downhill and just a terrible accident of two people, unfortunately.
And he reckons his brakes weren't working, usual excuse. Anyway, viewers, on that note, we've got to go to our sponsors' break. Stay tuned. After the break, we'll give you an update in work colour. Viewers, welcome back to the show. The first case we're going to do is a matter of Loney and Greif Investments Proprietary Limited. Toby, do you want to give us the facts of this? This is a case that our firm actually took to court.
That's right, Tony. So this is a case about a woman who was injured. She worked at a bar at Monash University and she was leaving work, and my understanding is she tripped and fell and she suffered injuries.
Yes. And John, many, many years ago, and I think it could be over 20 years ago, they did away with journey accidents, but there are exceptions to this rule.
Yes.
Okay?
Yeah, but it depends on the context of the situation. And in this case, we've got a female that's working at a bar in the Monash University Caulfield campus, Tony.
Yes.
Now, it's inside the campus. She has to work there. The bar had just started up. She's working there for a few weeks. She's doing a lot of jobs, a lot of work for the bar, bringing in goods. As part of her employment conditions, the employer paid for her parking permit, which was close to the bar.
Yep.
Now, the way she walked, the way she traversed from the bar to her car was via this path, a designated path. However, at a point in the path, Tony, you could take a shortcut.
Yes.
And everyone took this shortcut. On the night in question it was late at night after a big night at the bar, as in she was working. She's going back to her car, so she's finished work.
Yes.
She's going back to her car. She takes this shortcut, which is just slightly off the designated path,
yes.
Which everyone else does, and she falls and sustains serious injury.
Yep.
Now, the claim is accepted initially by WorkCover, the WorkCover insurer, for weekly payments and medical expenses.
I think they accepted it for 98C purposes too.
And for 98C, impairment benefits claim.
Yeah.
They've accepted it. After a few years, however, and this just happens during the time of the damages proceeding, the WorkCover insurer changes their mind. They terminate the claim on the basis that,
It's not work-related.
we think it's not work-related because you've gone off on your own journey. What you've done is actually outside of work.
Yes.
Now, we fought this, the Wiki Carbone fought this very hard, Tony, as you know.
Yep.
We had to take it to the magistrate's court on this point of law as to whether or not the injury was caused at work.
Yes.
Now,
well, the thing that there's a Henderson principle which came into play after the amendments in 1992, and effectively it says that if the workman is reasonably required, expected, or authorised to do in order to carry out his actual duties. Well, in this case, she was taking laptops home. She was doing work at home too, Toby. So
that's right, and that's what the court found, that in fact what she was doing was reasonably required of her, and therefore it was a work injury. It did arise out of her work.
Now, and also part of that was the close nexus and proximity to work itself.
Yes.
Now, if she'd got into her car and driven away,
well, if it happened outside the Monash University car park, it would have been a problem, I would have thought, John.
Exactly, you'd probably say that the nexus has been broken.
Nexus. Yeah.
But here, she hasn't reached her car yet. She's on her way. She's finished work. She's left work and on her way to her car.
Yes.
She's fallen over. Court found that, well, that's sufficiently close proximity that this is a work event.
All right, can I ask you this question, John? Hypothetical, you too, Toby. Because she was doing a lot of work at home, right? She took software home. She had documentation, records for the employer. She was doing bits and pieces at home. Let's say she fell over at home. Would she be covered? Because she was working. Don't forget she was working. John, if she can prove that she was working, why wouldn't she be covered? It is a workplace. The employer's actually approved her working from home. How often have we done it at our office?
Well, it's interesting in this case because the court said that they'd specifically discussed how she'd get to the car and that she was doing that sort of work. So perhaps there is a bit of potential there if it's a...
Well, if you're working at home and you slip over on a floor during the time that you're working, I can't see why that's not a work accident.
I think it really would have to be what the setup was, Tony.
Okay.
If she's just working at her kitchen bench and it's a haphazard setup, do you know what I mean?
Yeah, but it raises other issues too. The employer's still got to investigate to make sure that it's set up properly.
Yeah. If she's working in an office at her home, which is been set up specifically, the employer's come and looked at what's gone on. Yes, approved that. Different story.
Exactly.
But if it's a haphazard setup, I'm not sure.
Well, Toby, John, that just raises the issue I'm about to say. It is so complicated that you need specialised legal advice. Always. So at Wiki Carbone, you run the WorkCover department, 1300 injured.
We can advise viewers on all your work injuries and those times where it's grey, where you think, oh, well, I'm doing work, but I'm not actually at work. So is this a work injury or not? Please contact us at Wiki Carbone and we can advise you as to your entitlements.
And there's plenty of people that can advise, isn't there, John?
Oh, yes.
Yes. All right, let's move on to the next case. Zealy and Liquorland Australia Proprietary Limited, Victorian Supreme Court, Toby. Can you give us the facts of this case?
Yeah, I can. This is a case where the plaintiff suffered an injury to her back when she was assisting unloading some goods from a truck. Now, it wasn't actually her truck or the employer's truck. It was the truck of a transport company, Linfox.
Yes.
And what seems to have happened was, unfortunately, the person who was delivering the goods wasn't expert in how it was to be done, and she was required to assist, and in doing so, she suffered an injury.
Well, John, the case was actually settled, and this proceeding was about contribution and what contribution towards the damages should be paid by Linfox and what part should be paid by Coles.
Exactly.
And there was a lot of interesting aspects to the case. Tell us how the court went through it to work out who should pay what.
The court, Tony, was scathing about Linfox's involvement.
Yes.
As in, they've provided this truck driver to come and deliver the goods to Liquorland.
Yes.
However, the training was a bit
haphazard
to say the least,
yes,
wasn't it, Tony?
Yes.
And the court was scathing about Linfox's training of the driver and their responsibilities. Now, the court had to decide, well, who was responsible for what? As in Linfox's driver, then the employees of Liquorland, and how were they responsible for the injuries? Now, in the end, Tony...
well, before we get to the end...
Yes?
What's a non-delegable duty of care, Toby?
Well, Tony, the law recognises that an employer has a non-delegable duty, so they can't, of care to their employee. So they can't say that it's somebody else's duty, it's their duty to provide a safe...
Well, you can't handball the responsibility in effect.
That's right, and that's why in this case where there's two parties involved in potentially causing the injury, the court has to look into, well, what's their respective contribution, and that's what the case
Their
is
respective
about.
culpabilities.
That's right.
Yeah, and Linfox was responsible for the...
We'll keep the suspense going here, John.
Okay.
Viewers, we've got to go to a sponsors break. After the break, we'll tell you what the court found. Welcome back to the show. Before the break, we were talking about this case, and John was going to give us the result.
The result, Tony, was the judge, again, as stated previously, he was highly critical of Linfox's involvement in regards to the training and lack thereof of the employee, the driver. In the end, the judge found a 65-35 apportionment.
Yes.
65% to Linfox, 35% liability to Liquorland. However, Liquorland were responsible for the return to work and retraining of Mrs. Zealy.
And she aggravated her injuries.
Her injuries were aggravated by the return to work program.
Yes.
And we find this quite often. It's a complaint by workers that return back to work.
Yep.
The employer's pushing them too much.
Exactly.
Trying to get them to do the normal duties when clearly, the return to work program is to be modified duties, light duties. But as we all know, employers really don't have that. They want the employee to just get back to normal duties.
Full productivity, yeah.
He found that she did suffer an aggravation, though minor, and therefore again adjusted the responsibility, the apportionment between the parties
58.
to 60-40.
Okay.
It was 60-40, so you just took off 5 from Liquorland and gave that to Linfox. So it's a 60-40 apportionment of the damages that were to be paid to Mrs. Zealy for her injuries, Tony.
Viewers, we've got another case of Sandra Bernadette Fullick and Durox Proprietary Limited New South Wales decision. Just briefly the facts, please, Toby.
This was a matter where the plaintiff suffered an injury and it was a case really about whether there was any liability against the employer. She was placed with Durox, where she suffered an injury through her employer, who is a labour hire company.
Yes, which happens quite a bit in this day and age.
It does. It's a very common arrangement. And then in this case, the court really was looking at, well, is there any liability for the injury against the employer? There's this concept of a non-delegable duty of care. But in this case, it was said that because the injury was caused really by a lack of supervision, which Durox, I think it's Durox, were responsible for, that really the employer, there was no liability against the actual employer. So that's what...
I find that extraordinary because in Victoria, John, the employer's got a non-delegable duty of care to ensure that the workplace they sent them to has had a proper safety inspection to see what the tasks are. I think it wouldn't be like this in Victoria.
I have to admit I'm troubled by this decision. To say that the employer has no responsibility whatsoever
is surprising.
It is. Understandable that the occupier, Durox, who failed to properly supervise the worker here, yep, that's reasonable.
Yeah.
But to say that the employer has no responsibility whatsoever,
it's a bit rich.
Well,
they've got to undertake a risk assessment, which it doesn't appear occurred in this case, isn't that right, Toby?
Exactly.
Well, I agree with that, Tony. I mean, surely if there was a risk assessment, they would have looked into the supervision aspect as well as just the general safety.
Tony, it just shows how harsh the New South Wales work cover system is as compared to the Victorian work cover system.
You're not wrong. It is very complicated.
I have to admit, I've never seen a decision like this in Victoria.
No, I would have thought that there would have been culpability on the employer as well. There's no two ways about it. There's this sad and interesting case of the young fellow on the roof, case of Marwood. And he's come off the roof and sustained quite nasty injuries. Do you want to give us the facts of that case, please, Toby?
Yes, sure, Tony. So, as Tony, you've said, this was a young worker. He was up on the roof. They'd been doing some work up there. I think it was about 2.8 metres high. And it started to rain. He hadn't, my understanding is he hadn't been up on a roof to do work before. And he was ordered to come down, and as he came down, he unfortunately fell from an unguarded section of the roof and suffered injury.
It's really strange that it was the first time on the roof, John, and he was told to come down off the roof. It was coming down off the roof where he fell, and it was the only part of the roof that didn't have any scaffolding or guards.
Unfortunate, Tony, unfortunate. However, the roofing company and the subcontractor were found to be liable for his injuries. They both have responsibilities, Tony, for the safety, and they've got a duty of care. However, for the worker. However, again, there was a question of apportionment here, wasn't there, Toby?
There was. And I suppose unlike the case we were discussing before, the New South Wales case, it was found that both the employer and the other subcontractor who were involved in setting up the site and looking after the site were liable for the injuries.
Well, generally, the High Court's found that when there's independent contractors, they don't want them covered, but there are exceptions to the rule, and that was set out in Latent Contractors and Fox.
Oh, yes.
And in that case, the High Court said the duty of principals to independent contractors. Common law does not impose a duty of care on principals for the benefit of independent contractors engaged by them of the kind which they owe to their employees. However, it is recognised that in some circumstances, a principal will come under a duty to use reasonable care to ensure that a safe system of work for one or more independent contractors is safe. And we see this a lot in the building industry, don't we, John? Because, there's one person responsible for
one
the safety of all.
Yes. And then one aspect of the site. And this raises a similar issues that were raised, Tony, with the wall collapse in Swanston Street.
Yes.
Where Grocon and Aussie Signs, the subcontractor, were both found liable for the deaths of those poor young kids that were going to uni on that, fateful day where Grocon, they're responsible for the site as a whole, had engaged Aussie Signs to do the signage, and as a subcontractor, they were both fined, if I recall correctly, $250,000, Tony, by the Magistrates Court.
And Toby, the families of those young students that died, they'd have claims, wouldn't they?
They may well have claims here, Tony.
Psychiatric injuries?
Psychiatric injury.
Under the Wrongs Act in Victoria.
Exactly.
Yeah.
Oh,
Am I
yes.
wrong, Steve?
Oh,
Yeah.
yes.
And what, you need a 10% whole person impairment. However,
Yes.
you'd think that once they get past that grieving stage, they'd be left with some sort of psychiatric injuries,
For
wouldn't
sure.
you?
Yes, exactly,
Toby?
Tony.
I would, unfortunately, there's a lot of potential for that.
Look, John, is there anything else you want to say about these sorts of cases? Because they are complicated.
They're complicated, viewers, and this is where we advise workers quite often. If you've been injured at work, a lot of times you might think, oh, this is not work, or I'm not insured for this. Well, no, you should seek the advice of an experienced personal injury lawyers, such as us at Nowiki Carbone, where we can advise you on what your entitlements are and who the right people to lodge the claim with are, Tony.
Exactly. Toby, you'd endorse that, wouldn't you?
I would.
Yep. Anyway, on that note, Toby, thanks for coming on board. John, always a pleasure.
Thank you.
Viewers, thanks for watching. Stay tuned for future episodes. Go to YouTube for our past episodes. Go to our social media platforms, and always remember to stay safe.